Welcome to the deep dive. Today we're tackling something pretty specific, really quite technical actually. We're looking at the legal maze U.S. residents face when they need to handle important stuff back in the Russian Federation. Think property, inheritance, that kind of thing.
High-stakes administrative matters.
Exactly. We've gathered material on how to make U.S. legal documents work in Russia. We're focusing particularly on New York notary powers, meaning Russian legal standards.
Yeah, it's a specialized area.
Our mission today, to give you a clear guide on creating things like powers of attorney, POAs, or official statements here in the U.S. So they're actually accepted over there for really critical actions. Selling an apartment, claiming an inheritance. It's a real deep dive into getting the details right.
And details is definitely the word. Precision is everything. This isn't just about getting a stamp on a paper. It's understanding that even signing a document involves knowing bits of New York law and Russian civil code.
Really? Both?
Absolutely. Miss one small thing, like maybe forgetting a specific ID detail, that could totally derail a transaction you've spent months setting up.
Okay, right. So let's unpack this. Let's start with the main tool people use. The power of attorney, the POA, specifically for Russia.
Right, the POA. That's your main way to get things done remotely. Generally, you see three main types. There's the general POA, which is quite broad, then a special one, maybe for a specific court case, or like a one-time POA just to pick up some documents.
And what's the core Russian legal rule here? What makes it official over there?
Okay, that brings us straight to the Russian Civil Code. You need to know Article 185, Paragraph 5, it's critical. It says notarization is mandatory for any POA issued by an individual. So if you're just a person, not a company, it must be notarized. No ifs, ands, or buts.
Got it. Mandatory notarization for individuals. So let's make it practical. I'm in New York. I need to authorize someone in Moscow. What exactly do I need to bring to the notary? Because, the sources really stress the ID part is different than usual here.
It really is. You obviously need your valid ID, like a passport. But if you're a Russian citizen, the strong advice is to include details from both your international passport and your Russian internal passport.
Both. Why both?
Because so many rights in Russia, property rights, civic rights, are tied specifically to that internal passport number and record. You need it listed.
Okay, that's a key detail. What else?
You'll also need scanned copies of the ID for the person you're appointing, your representative, and crucially, documents supporting the action you're authorizing.
Like what kind of documents?
Well, if it's real estate, you need the title document or the EGRN excerpt they use now. Selling a car, the vehicle registration, the PTS, inheritance or dealing with kids, birth certificates, death certificates. You basically have to build the whole case file, legally speaking, right from the start.
Right, so the authorization is clearly linked to the specific asset or action. Makes sense. And once it's all signed and notarized here in the U.S., what's next?
Then you need the apostille. That's the global bridge, as you called it.
Yes, the apostille.
Exactly. It's based on the Hague Convention. It verifies the notary's signature and authority for international use. Without that apostille stamp, your U.S. notarized document is basically worthless in Russia.
Non-negotiable then?
Absolutely non-negotiable.
Now, what about language? I saw a note that was interesting. Does the POA have to be in Russian?
Good question. New York state law is actually pretty flexible on this. The notarization itself can happen with the document in any language, Russian, English, Chinese, whatever. The key is that the notary certificate, the part the notary adds, meets the New York requirements.
So I could have it done in English.
You could. But if the person signing, the principal, isn't fluent in the language of the document, the best practice, really, is a bilingual format, parallel text, side by side, ensures everyone understands exactly what's being signed.
Okay, bilingual for clarity. Got it. Now, here's where our sources say things get really interesting and complicated. Property sales.
Yes, this is often the biggest hurdle.
Why? What's the issue?
Well, notaries or officials in Russia often push back hard against U.S. notarized documents for property deals. Their argument comes from Article 185.1 of their civil code. They interpret it to mean the notary shouldn't just check the signature, but also confirm the signer's legal capacity, their right to sell, basically doing a title check.
But wait, a standard U.S. notary public can't do that, right? They're specifically told not to verify the contents or the signer's rights, just the identity and signature.
Exactly. That's the conflict. A standard U.S. notary cannot legally perform a Russian-style verification of legal capacity and title.
So how does this even work then? It sounds like any U.S. notarized POA for selling property is doomed to fail in Russia. Is there a workaround?
There is, but it's very specific. It hinges on the authority granted to a New York notary public who's also a licensed counselor-at-law, an attorney.
An attorney acting as a notary.
Precisely. New York Executive Law, Section 135, gives NY notaries a very broad, kind of open-ended list of powers, and crucially, it includes the power to perform acts according to the laws of any other government or country.
Whoa. According to foreign law. That's huge.
It is. So if the notary is also an attorney, and they have qualifications relevant to that foreign law, like Russian law in this case, they can make a specific statement in the document. They state they are acting not just as a notary, but under their authority derived from NY law and pursuant to the requirements of Russian law, verifying capacity and rights as required by Article 185.1.
So the attorney notary is essentially leveraging their NY license to perform an act required by Russian law, something a regular notary couldn't touch.
You've got it. They bridge the gap, they satisfy the NY requirement by acting within their broad powers, and they satisfy the Russian requirement by explicitly addressing the legal capacity check.
That is quite a clever legal maneuver. So does this mean you need to include extra proof, like the notary's law license?
Absolutely. The best practice, according to the sources, is to include copies of the notary's legal licenses, maybe even diplomas showing relevant expertise, right along with the POA and apostille. It builds a bulletproof package for the Russian authorities, showing that the specific requirements of their law were understood and addressed during the notarization in New York.
Okay. That explains how to handle property sales. That's a major clarification. Now, shifting gears a bit, let's talk about inheritance, transferring assets after someone passes away.
Right. Another area fraught with potential problems when you're doing it from the U.S.
The sources mention some serious risks. What are the big ones we need to flag for listeners?
There are three main dangers you need to watch out for immediately. First, and this is a big one, missing the deadline. You only have 6 months in Russia to accept an inheritance.
6 months from the date of death.
6 months from the date of death, or from when a court declares someone deceased. It passes faster than you think, especially with international mail and complexities.
Okay, deadline is number one. What else?
Second risk, losing the assets. If you don't act, property could fall into disrepair, accounts could be frozen or depleted, improper management before you secure control. And third, other people might challenge your right to inherit. Other potential heirs, creditors, maybe. You need to assert your claim properly.
That 6-month clock sounds brutal.
Yeah.
How do you formally accept, according to Russian law, Article 1153, I think?
Correct. Article 1153 lays out two paths. The first is formal acceptance. That's the straightforward way. You file a written statement with the specific notary handling that inheritance case within the 6 months.
File statement.
Okay.
But what if you're struggling to get that done? Maybe delays, getting documents from the U.S., finding the right notary there. Is there another way?
Yes, thankfully. There's factual acceptance. This is about your actions, not just paperwork. If you do things that clearly show you're taking possession, like you start managing the deceased's apartment, pay their utility bills, pay off their debts, even just take steps to protect the property from damage or other people. Those actions, if you can prove them later, can count as acceptance, even if you missed the formal filing deadline.
Interesting. Actions speak louder than words, potentially.
Mm.
Now, you mentioned paying the deceased's debts. That sounds like it could be a double-edged sword.
It absolutely is, and this leads to a critical warning.
Okay, what is it?
When you accept inheritance in Russia, you accept it all. The good and the bad. You cannot pick and choose.
Oh, yeah.
If you accept the assets, you are legally stuck with all the deceased's obligations and debts.
Wow. So if the debts are actually higher than the value of the assets?
You could end up losing money by accepting the inheritance. That's why the absolute first step before you formally accept anything must be a thorough valuation. You need to know the net worth assets minus liabilities.
That is crucial advice. Get an appraisal, check for debts before signing anything.
Precisely. Don't lock yourself in until you know the full financial picture.
Okay, so inheritance is tricky. What about planning ahead to avoid some of this? If someone wants to transfer property now while they're alive, how does gifting compare to using a will?
Good question. A will or an inheritance contract changes who inherits later. But a contract of gift, what they call a darstvenaya in Russian, transfers ownership now. It has some advantages. If the person gifting owns the property outright, you often don't need a notary for the gift contract itself, which saves fees. And the recipient gets the rights as soon as the transfer is registered with the state. It's immediate.
Sounds simpler. What are the downsides of gifting?
Well, it's pretty much irreversible unless there are grounds to invalidate the contract entirely, which is hard. But the biggest catch is usually tax.
Tax? How so?
If the person receiving the gift isn't a close relative, spouse, parent, child, sibling, grandparent, grandchild, they face a hefty gift tax. It's 13% if they're a Russian tax resident, but a whopping 30% if they're not a Russian tax resident.
30%. Ouch. Okay, so gifting is really only tax efficient between very close family members.
Generally, yes. You really have to factor in the recipient's relationship and tax residency status before deciding to gift property.
All right, we've covered the big money topics, POAs, property, inheritance, gifts. What about the more routine but still necessary administrative stuff, like residency registration or military service records? How do you handle that from the U.S.?
Let's take residency first to propiska, registration at an address, or vypiska, deregistration. In theory, the rules from the Ministry of Internal Affairs, the MVD, say you can deregister by sending a notarized and apostilled statement through the mail from abroad.
Okay, sounds simple enough.
Yeah, in theory. But the reality on the ground, especially in big cities like Moscow, the sources say the local registry offices often refuse the mailed statement.
Seriously, even though the rule allows it.
Yep. They often demand someone show up in person with a POA and the person's original internal passport. So even for something seemingly simple, you might still need that representative on the ground with a properly executed POA. It can be frustrating.
Sounds like it. Bureaucracy hurdles? What about the military registration? The Vonkomat. I heard there was a recent change there.
That's actually some good news. The law did change recently, and it now explicitly allows for remote military deregistration. You don't have to physically go there anymore.
Oh, that's a significant improvement for people living abroad. What do you need to provide for that?
You need to submit a completed application form. You also need to send your original military ID, the Vony Billet, and critically, proof that you plan to be outside Russia for more than 6 months.
What kind of proof works?
Things like a foreign residence permit, a green card, a certificate of employment abroad, something official showing long-term residence outside Russia. And while the law allows remote processing, it's still highly recommended to also prepare a separate, specific POA authorizing someone to represent you before the military commissariat, just to smooth the process.
Okay, so still might need a POA, but at least personal appearance isn't mandatory anymore. That helps. One last detail, getting copies of documents certified in New York. There seems to be a specific rule about government documents.
Yes, this is a key New York notary limitation you need to know. NY notaries are generally prohibited from making certified copies of U.S. public records or government-issued documents.
Like birth certificates or court orders.
Exactly. Birth certificates, death certificates, marriage licenses, court judgments, things like that. The notary cannot just photocopy it and certify it as true. It's mainly about maintaining the integrity of official records.
So if you need a certified copy of, say, a U.S. birth certificate for use abroad,
you have to go back to the source. You order an official certified copy directly from the Vital Records Office or the court that issued the original document. That's the only way.
Okay, so no shortcuts there. What about other documents? Private ones or maybe foreign documents?
For those, the New York notary uses a different procedure. They don't certify the copy itself. Instead, the owner of the document signs an affidavit, a sworn statement. In that affidavit, the owner swears under oath that the photocopy they are presenting is a true, correct, and complete copy of their original document. The notary then notarizes the owner's signature on the affidavit.
Ah, I see. So the notary isn't vouching for the copy. They're vouching that the owner swore the copy was accurate. It's a subtle difference.
It is subtle, but it's crucial legally, especially when that document package goes overseas. It clarifies exactly what the notary did and didn't do. Tying this all together, it really shows that dealing with these cross-border legal issues isn't about, choosing sides between legal systems. It's much more about understanding how to translate requirements and use the specific tools available, like that special power of a New York attorney notary acting under foreign law, or knowing the difference between formally filing for inheritance versus just acting like an owner.
Right. It's about finding the bridge between two very different, very specific legal worlds, and knowing the precise steps to make that bridge stable.
Exactly. And using things like the apostille correctly, getting all the ID details right. It's about meticulous execution.
It definitely highlights that getting compliance right often needs really specialized knowledge. Someone who understands not just the laws on the books, but how things actually work or don't work in practice in registry offices or notary chambers in both countries.
Yeah, the practical implementation is often where things succeed or fail.
Absolutely. It's about making sure the paperwork actually gets accepted where it matters, not just getting it stamped here. So as we wrap up our deep dive today, the source materials brought up something interesting we didn't fully explore. Consent for a child to travel internationally. Apparently, U.S. requirements are quite minimal, but Russian law and laws in places like the Schengen area in Europe can be much stricter and vary quite a bit.
Parental consent for travel is a whole other complex area.
So here's something for you, the listener, to think about. Just how much difference is there between major destinations, say France versus Germany or maybe Japan, when it comes to the exact consent documents needed from the parent who isn't traveling? And how could those variations mess up last-minute travel plans if you haven't prepared precisely the right kind of notarized consent? Something to maybe look into before your next international family trip. Until our next deep dive.